I'm talking again to Dahlia Lithwick from Slate, slate.com. Let's actually move on because just today, on Monday, the Supreme Court has actually refused to hear a case involving a New Mexico wedding photographer and a lesbian couple. And the implications of this when it comes to the Hobby Lobby case, which they're still deliberating on right now, are pretty crazy. So tell us a little bit about the case that the court actually refused to hear.
Right. This is an incredibly interesting case that lives kind of right at the margins of the court's gay marriage jurisprudence, right? The stuff that came up last June where the court pretty tentatively said that you can't discriminate against gay couples, and exactly the jurisprudence you're describing in Hobby Lobby, which is these claims of religious conscience or religious objections from individuals who have problems with just general laws. And so this case lives right at the middle of those two spaces. And this is, there's a New Mexico law that says that businesses that are just generally open to the public can't discriminate against gay people, and yet there's a photographer in New Mexico who says, hey, I'm not discriminating, but I will not take wedding photos of gay people, and she actually declined to do so for a lesbian couple. The couple sued under the New Mexico statute, and Elaine Photography, the photographer, loses in the courts and then goes on to lose in the New Mexico Supreme Court, where the court says, yes, you may or may not have First Amendment rights, Elaine Photography, in taking the pictures you want to take, but when you open your doors, and hang out a shingle saying, I'm a wedding photographer, you take all comers, and to decline to serve only gay and lesbian couples is discrimination. And so the court, as you said, declined to hear that case today. That means that the lesbian couple in question prevails in the lower courts. But I think the real question is how the court is going to square this kind of litigation. And trust me when I say there will be lots and lots more of it, with the decision they may make in Hobby Lobby, where, at least after oral argument 2 weeks ago, it looks as though the court is going to say that there's some kind of religious conscience right, even for corporations, for-profit corporations, to opt out of neutral, generally applicable laws if their religious faith is violated. So how to square those two? Well, that's the question.
Well, so you did write about this when the case went down. What? Because again, you write that, again, oral arguments, sometimes they go the opposite way. Sometimes they're just making an argument for show or to get things on record. But the Hobby Lobby case, it looks, from what you write, it looks like the contraception mandate is doomed, right? That if you strictly look at the oral arguments, it looks like we're going to probably have another 5-4 vote that allows this to happen. I mean, again, you never know, but just from watching it, that's sort of your what you think here.
I mean, look, we're all wrong all the time, and especially
sure.
on a court where,
absolutely.
You're looking at Justice Kennedy's nostrils to see which way he's going to go, and it's crazy making, and so one is loath to predict. But it certainly did seem that Justice Kennedy was deeply, deeply concerned. If you're going to try to sort of telegraph from the questions he was asking at Hobby Lobby, he seemed deeply, deeply concerned with two things, and then we can talk about which overmasters the other. On the one hand, he was very concerned, and in fact, he was one of the only justices who strongly evinced a concern that the employees of Hobby Lobby, of which there are thousands who are not evangelical Christians like they're the owners of the corporation, that those people have rights at issue too. And he said, how is it possible that none of their rights matter? And then he asked, does Hobby Lobby's rights just trump? And so on the one hand, it seemed as though he had some solicitude for the fact that there were third parties here, right? So many of these religious conscience cases, there isn't a third party who's involved. Here, it's just the government against the objector, and you work out the equities. This one is very tricky because there are third parties. There's thousands of third parties, women who want, IUDs, or they want Plan B or Ella, and they can't get them. And Kennedy was quite worried about the fact that their rights were burdened. And so that was, I think, gave some hope to folks who support the mandate. But as you say, and I think was pretty evident at argument, he also was very, very concerned, and I don't think got a great answer from the government, about if a corporation can be forced to give employees, contraception over their religious objection, can you also force them to pay for abortions over their religious objections? And he felt that he didn't get a satisfactory answer. And if you know how Justice Kennedy feels about abortion, it's quite worrisome that he sees that he can't draw a clean line between Hobby Lobby and the corporation that doesn't want to pay for abortions. And so that was very worrisome to him. And I did sense that the Chief Justice was going to try to find a middle way in this case, which would have given Hobby Lobby the win. And what it would say is, look, Hobby Lobby is different from other big corporations because it's closely held. It's a family corporation. Let's just decide this in favor of Hobby Lobby today. And when Starbucks or Google comes along and, says they have a religious objection and it's not a tiny family corporation, we will decide that for another day. And it looks like if that's the compromise, then we really are, going to live in a world where we're at the mercy of our employers when it comes to contraceptive care.
Well, again, if you follow the twisted logic of the Supreme Court from, Citizens United, that corporations are people, corporations have First Amendment rights, then theoretically, why wouldn't a corporation like Hobby Lobby have First Amendment rights of religion as well? Which again, this path that you start to go down once you've granted, a non-person personhood is maddening and potentially just frightening as hell. Talk a little bit about because we talk about the Mexico wedding photographer case, but what are other potential giant implications other than just contraception? Because once this door once the floodgates open on this type of ruling, so many laws and potential discrimination things could come out of this.
That's exactly right. And each of those got raised and discussed at oral argument. What do you do about the Jehovah's Witnesses? What do you do about, the deeply faithful Muslim business owner who thinks women should wear burqas, right? All this gets introduced, and it is clearly a slippery slope. Blood transfusions, AIDS medications, even basic, equal pay for women, or as you said in the photography case, anti-discrimination laws about gay Americans. All of those can get swept into the deeply felt religious objections of the employer. And so it's not just, one or two hypothetical cases. It's fairly clear that, basic architecture of civil rights law in this country could be under attack if every single employer can say, you know what, I'm just not going to pay for blood transfusions, or I'm not going to pay for AIDS medications. And it was deeply interesting, actually, at oral argument that Paul Clement, who was defending Hobby Lobby in this case, his answer was, well, this is different because this is really sensitive. There's something sort of sensitive about birth control. In this case, they don't think it's birth control. They think it's an abortifacient. But whether you call it birth control or an abortion, that this is somehow different from blood transfusions or AIDS medications or
I think it's sensitive to the people who care about that. I think would find it sensitive. I think those people who have those, who feel that way about blood transfusion probably feel pretty sensitive about that.
Well, that's a pretty deep. That's exactly right. And that the court, putting the court in the business of determining which are the sensitive religious convictions is, the path to madness. And, as you said in your question, part of the whole problem with corporate personhood generally, and this goes back, as you said, to Citizens United, is which part of the corporation? Is it 51% of the shareholders? Is it 57? Is it 42? What if only 3% of the corporation's shareholders have deeply felt religious convictions? The reasons that we don't say corporations are people is because they are comprised of lots of people with lots of different views.